my lord and my lady. My name is Muthomi Thiankolu for the second interested party, and to that end, we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have, in addition to that, filed a list and battle of authorities on that preliminary objection, and that list and battle is dated the 25th day of October 2024, and pursuant to your directions, those are the battles, my lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have, in addition, filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I had forgotten to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO, and you find that I deserve to be laughed at, it's okay. My lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution, to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My Lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this, that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My Lord, it is clear by dint of Article 58 sub Article 5 that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngwe, talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear if you have a dispute as to that matter. Never mind that he has abrogated the entire Bill of Rights. The court you go to is not the High Court. It is the Supreme Court. My Lord, property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not without more mean that this court has jurisdiction to hear that matter. In other words, my Lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my Lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gidum Wige's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my Lord, the Bado of Authorities. We have produced you, rather before you, extracts of the Bomas constitutional, the Bomas draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether these matters should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one. A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Bomas process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course we know, my lords, the Bomas draft was one of many. The next draft that was generated in that process is at page 7 of our BADO, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-article 4, that the Supreme Court has, paragraph A, exclusive, underline exclusive. We move from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was a work or draft. We have produced it at page 10 of our battle. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is a draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there will be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144. Yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our BADO. My lords and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you, 144, Article 144(8) of our Constitution, is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall so communicate. And of course it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9, and when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the $1 million question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my lord, we are told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojeda is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years now and counting. Why this decision is important, my lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you check the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life, to the extent that he refused to resign, it meant the US Treasury was bound to continue paying his salary an emolument while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives and the Senate, took up impeachment and impeached this judge. But when you follow the holdings in this case, my lord, they say at page 20 of Wabadu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said, following this decision, that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US, the Supreme Court of the Republic of Kenya. And my lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General Emeritus Professor Muigai, if you go to page 21, my lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Bado. And the reason I'm referring it to you, my lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable, but there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make heavy weather of the idea that this type of dispute is not justiciable. Lastly, you are told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our Bado. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my lord, when all is said and done, is to do either of two things. Hold, you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked. Let him fight at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you.